90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is Attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. My special guest today is Attorney George Terezakis. He has a practice-based where he handles family-based migration and deportation defense, especially to the Spanish community in the New York area. He's fluent in Spanish, and he's going to translate key portions of what he has to say into Spanish, and there's more information available in English and Spanish on his website. He'll give you a little bit later. He's been practicing for 30 years, has handled all types of situations. In this program today, he's going to talk about what is the process by which a non-citizen can become a lawful permanent resident, in effect, have a green card. George, welcome back to Law You Should Know.
Ken, it's so great to be here. I want to thank everybody here at Nassau Community College at WHPC, and I'm really excited to talk about this topic.
Okay, and just mention that you will be translating some parts of it into Spanish, and there's more information available in Spanish on your website.
Sure. Por algunos que no hablan inglés, vamos a hablar un poco en español, uno de los puntos principales.
So first tell us, George, about the different ways a person can try to begin the process.
Sure, Ken. I think the most important thing to say from the outset is how important it is to make sure you use an experienced immigration attorney. Unfortunately, the immigration law is extremely complex, and sometimes people try to save money, and they use what's called a notario, or someone who's not licensed to practice law. And I can't tell you how many cases I've seen where people went to someone thinking they'd help them, and they either defrauded them, took their money, disappeared, or filed frivolous applications that ended up causing them to lose the ability to actually become a legal permanent resident.
And those people may also be violating the law and practicing law without a license. A notary has a different meaning in New York and in the United States than it does in South America, and they're not allowed to practice law or give legal advice in New York.
Exactly. And so I would say in Spanish, nunca uso un notario o alguien que no es un verdadero abogado, porque hay demasiados casos de estafadores que han aprovechado de los inmigrantes.
And there may be some free legal services that provide legal services and community organizations, but again, make sure you're dealing with a licensed attorney or some kind of legal clinic.
Exactly, Ken. It's very important to make sure that you're aware of that from the outset.
So what are the most common ways that someone can help a relative to legalize them in this country or bring them into this country legally?
There's a number of different ways, Ken. It really depends how the person or what the person's situation is. There's different rules that apply if someone's outside of the United States or whether they're already inside the United States. And if you'd like, I'd like to discuss some of the common ways.
Absolutely.
For example, primarily, we'll be speaking about family-based immigration. And for family-based immigration, it starts with a petition filed by a family member. Usually it's a spouse, a parent, or an adult child petitioning for someone living outside the United States and applying for them to become a permanent resident. And to start that process, they must file a petition for what we call an immigrant visa.
And if someone is, let's say, a sibling or, it's like their aunt or nephew, it doesn't work as well.
What we have are instances of what we call immediate family members. A classic example of an immediate family member is a spouse that's a U.S. citizen petitioning for their spouse.
And when you say U.S. citizen, someone who's a citizen or a green card?
Correct. They may also petition if they're a lawful permanent resident. A parent can also petition for a minor child, and that would become immediately available. It's important that the petitions are prepared properly and filed, and if it is not an immediately available visa, for example, where a parent is applying for
just
an
to
adult
visit.
child or a married child,
Okay.
then you have certain priority categories, and they can take somewhat longer.
And we may be talking about even just like a visitor visa or just a... Or
Well,
it's
that
more like
would
a
be
family
a different
visa?
situation. What
Okay.
we're talking about here is where the petition is based on the family relationship. Sometimes we have other instances where someone applies to become a student or to work in the United States, and then that category would fall under people who are already in the United States and then want to change their status to become a permanent resident here.
And that may be some interesting way that a person can try to become a student here, whether it's community college or maybe high school or a trade school.
Yes, Ken. There's many ways that individuals from outside the United States may be able to apply to become students or to work here. But as far as becoming a permanent resident, the first step is to file the petition. That would establish the family relationship. And then once it's approved, you'd proceed with the consular processing, and ultimately there would be an interview at a U.S. consulate abroad. Generally, at that interview, the person would have to establish that they're admissible, that in the first instance that there's a valid family relationship, in the most common case of a spouse, a marriage, and secondly, that the person is able to support them, and that the person is not inadmissible on any other grounds.
And that marriage could occurred in the home country or possibly in the U.S.?
Correct, yes. They also look to see whether or not there's any issues of what we call admissibility. A person must be admissible to the United States. That means they can't have committed any, for example, could not have committed any crimes that make them inadmissible. And it's amazing how many different provisions of the law can render someone inadmissible. Even common things like a simple conviction for a non-criminal violation of possessing marijuana would actually render someone inadmissible to the United States.
And you do criminal defense work too, and that may become a lesser problem with recent changes in the criminal laws, or if pot is legalized to some extent.
Well, there's still an issue. Someone can actually be smoking marijuana lawfully, but they would still be rendered inadmissible if they go for their interview. And as part of the process of becoming a resident, they're going to check a physical, including your blood. And we've had many instances where people were outside of the United States, went to be checked for their physical, and were deemed inadmissible because of the presence of the marijuana. And they had to go through a period of counseling and showing that they're no longer using it. But with respect to the criminal convictions, sometimes there may be waivers that are available so that even if someone has a certain criminal conviction that renders them inadmissible, they can show hardship to a qualifying family member and still be able to gain legal status. Another common ground of inadmissibility is where someone has prior immigration violations. For example, they had previously been in the United States, overstayed their visa, or were previously ordered deported or removed from the United States. And in those situations as well, there are provisions regarding applying for certain waivers. It's fairly complicated, too detailed for now, but those who are listening should know that there are ways to apply for waivers.
And I'll let you just summarize what you've covered in Spanish if you'd like.
Okay. Hay maneras que personas pueden llenar y entregar una petición para una visa por sus familiares. Puede ser por su esposo o esposa, por sus hijos o hasta que sus hermanos. es un proceso que es más o menos complicado y depende de varios puntos. Por ejemplo, la persona no debe tener convicciones penales o antecedentes, violaciones de ley de inmigración.
And I just want to remind our listeners, you're listening to 90.3 WHPC, the voice of Nassau Community College in Garden City, New York. And we're talking with George Terezakis. He's an experienced immigration attorney practicing in his field for approximately 30 years. He's based in Mineola, but he handles cases and matters all over the New York area. And he also concentrates on family-based immigration and deportation defense. Keep in mind, this is also a podcast, so if you missed any part of it or you want to tell someone else about it, you can find it by going to nccradio.org.
You know, Ken, there's another point that happens in the course of that interviewing process and in the course of the application for an immigrant visa for the family member. And there must be a showing that the sponsor, the person who's petitioning for the immigrant, is able to financially support them. This is a big new controversy because the government's been really tightening up the requirements for a person to be able to petition for a family member. And one of the things that they've done now is made it much harder for an individual to show that their family member for whom they're petitioning will not become a public charge. So there's a whole big, fairly complicated now financial information that has to be provided to show that the person who's sponsoring this person will be able to support them.
And can there also be co-sponsors, other relatives or friends?
That's true.
Or employers?
Yes, in the instance where the principal sponsor or the petitioner doesn't have the all of the financial ability to support the family member, then they could have an employer, a friend, another family member sign on to co-sponsor them.
And just to go back to, you mentioned inadmissibility that will keep people from obtaining a lawful admission. The prior immigration history and entering unlawfully without inspection, just clarify what that means.
In many instances, people have been to the United States before. They may have come here lawfully on a student visa or on a work-related visa and then lost their status. Or perhaps they overstayed. It's common when someone's admitted under a tourist visa, for example, to be admitted for 6 months. Or if they come from what we call visa waiver countries, to be allowed to stay for up to 90 days. But if they overstay that, then they may trigger what are known as the unlawful presence bars. And then if they leave the United States to go back to their home country, they may now be subject to what we call a ground of inadmissibility. But based on a showing that a denial of an immigrant visa would cause extreme hardship to a qualifying family member, principally a spouse or a parent that's a U.S. citizen or lawful permanent resident, they may be eligible to receive a waiver of their unlawful presence.
Can you also get a waiver for visa fraud or using someone else's passport?
You may be able to get a waiver for certain types of fraud if you can make that type of showing. They're very difficult. And the best way, again, is to make sure that the person is using a lawyer and doing things properly. I can't tell you how many cases we've seen of people who are desperate to be reunited with their family members and so may use someone else's passport or an altered visa. And all that creates is so much hardship for the person, for their family, and it can also have criminal consequences.
So it's generally not a good idea.
Not a good idea at all.
And is there anything else that can be done if someone has been denied based on a finding that they've been inadmissible, in addition to what you've said?
Generally, you can make a showing following the interview at the consular office, because really now we're still talking about people who are applying for their family members who are abroad who are living outside the United States. Once there's a finding of inadmissibility, then the person has an opportunity, or their attorney can submit an application for what's known as a waiver. And that could be based on the unlawful presence. It could be based upon a criminal conviction and a showing of rehabilitation and extreme hardship.
And you mentioned it before, and I just want to remind everyone again that it's important to use a licensed attorney, someone who's licensed in the United States and even the state of New York, if it's in New York, not a notario or someone with a travel agency or a multi-service agency. Perhaps you can just reemphasize that, George.
We've seen so many cases where...
Spanish, too.
Okay. We've seen so many cases where people have gone to someone thinking they're going to be applying to get what's known as the 10-year green card based on having lived in the United States for an extended period of time, or they're applying for some type of benefit, and they go to one of these notaries or people who are practicing law without a license, and those individuals fill out fraudulent asylum forms, make up declarations under oath that the clients unwittingly sign without knowing what they're signing, and that can create a bar based on immigration fraud and ruin the person's chances of ever becoming a lawful permanent resident. So I can't stress how important it is for someone to use the services of a licensed attorney. Ken, I'd also like to talk a little bit about how someone who's already in the United States can become a lawful permanent resident.
Yes, that's very important. Go ahead, George.
Sometimes someone may have come to this country as a student or on an employment-based visa or on a tourist visa. And in certain instances, if they've maintained their status and if they marry a U.S. citizen, they can apply to adjust their status and become a lawful permanent resident. In other instances, a person may have come in legal status but lost their status, overstayed their visa. And in other instances, they may have simply entered the United States without inspection, without ever passing through a point of entry, without ever having legal basis for entering. Those individuals are not able to adjust their status in the United States. What they can do, however, is have their family member petition for them, file a petition for an immigrant visa, which is the process by which someone gains a green card. And then there's a waiver available which can be applied for right here in the United States, and that's called an unlawful presence waiver or provisional waiver of inadmissibility, a 601A waiver commonly referred to. And the lawyer would show the Immigration Service that that individual's parent or spouse would suffer extreme hardship if they were denied a waiver. It could be based on physical disabilities or physical hardship. The qualifying relative needs the immigrant to help care for them. Could be based on psychological hardship. There's many grounds, but if they all together require a showing of extreme hardship. But once that's approved, the final step would then be that the person would go leave the United States for a consular interview, and then they'd be able to return to the United States if it's approved.
So they could be taking a chance if it's not approved. They might have trouble getting back in.
Ordinarily, if the client's been truthful with the attorney, and usually the attorneys will review the client's immigration history. It's common in our office. We do a Freedom of Information Act request if they've had any prior contact with the immigration authorities. Review their records, make sure there aren't any bars that we're unaware of. And then if their only basis for applying for the waiver is based on unlawful presence and they don't have any criminal convictions, then it's almost certain, unless something comes up that they haven't disclosed, that when they go for that interview, assuming they can show the requisite family relationship, the financial ability, and generally good moral character, they will come back. What becomes a problem is if someone is here in the United States, has a criminal conviction, for example, that triggers inadmissibility, maybe a minor drug possession, maybe a larceny conviction. There's many different criminal grounds. But if a person has a criminal ground of inadmissibility, then they will not be able to apply for the provisional waiver. Their only recourse is either to apply for a waiver if they're eligible to adjust status, or they would have to leave the United States and apply for the waiver outside of the United States. But they couldn't cure that. Specifically, I know it's a little complicated, Ken, but the difference for the provisional waiver involves how the person initially entered. If they initially entered lawfully, they may be eligible to apply to adjust their status here and not have to do the consular processing.
And if not, they have to eventually go abroad.
But if they've entered unlawfully and they've never been admitted or paroled in the United States, then they're going to have to go
back before they pass go.
Correct.
So, and George, if it's important, if someone is facing a criminal consequence here, whether they're the sponsor or the applicant, it's very important they know the immigration consequences of their plea or of a conviction.
That's exactly correct.
And I know you deal with a lot in your criminal law defense, so I know that's so important.
I've been practicing criminal law probably 35 years and immigration law almost that long. And unfortunately, there are people who just dabble. They want to do a little bit of immigration law, but they don't really know about how a criminal conviction can affect their client's immigration status. And sometimes there's even folks who are more concerned about bringing in a client than what's best for that client.
So even if it's a very experienced criminal law, you've got to make sure you understand the immigration consequences of whatever your options are.
That's correct, Ken, especially if someone's here and they're charged with a crime. Before they take any type of a disposition, a reduced plea, they must ascertain with an experienced immigration attorney how that could impact their status in the United States. That's extremely
And many
important.
times there will be immigration, consequences. I just want to remind the listeners that you're listening to 90.3 WHPC, the voice of Nassau Community College. Our special guest is George Terezakis. He's an immigration and a criminal defense attorney and also fights deportation under the circumstances we've been describing. And today he's talking to us about how someone can become a lawful permanent resident. It's a very complicated area. George, you have more information available at your website, both in English and Spanish?
Yes, Ken.
Just tell us your website.
My website's nassawdefender.com, one word, or in Spanish, sudefensor.com. And we have information about some of these issues right there on our website. I think the most important thing when folks are in this country, and historically in the past, it was very common that people from other countries would come to the United States for a while and work, and even if they were out of status, they might return back to their home country, see their family for a while, and come back either as a seasonal worker or doing construction work or some of the other jobs that are so vital in our country and that we rely on immigrants in many instances to help us with. But after the laws changed, primarily with the Immigration Act in 1996, we had changes to the immigration laws that really started to make it extremely difficult for people who have left the United States and then re-entered unlawfully to be able to gain legal status. In fact, the laws were specifically designed to make it hard, if not impossible, for someone who had accumulated unlawful presence after entering the United States unlawfully to gain legal status. Those bars, those grounds of inadmissibility for unlawful presence are triggered once that person leaves the United States. So the problem we have is where someone's come to the United States unlawfully, lived here for a period of a time in excess of 6 months or in excess of a year, and you trigger what are called 3 and 10-year bars inadmissibility based on unlawful presence. So if someone comes here unlawfully, stays past a year, leaves the U.S., now they face a 10-year bar.
So can you help them relieve the consequences of those bars?
Those bars you can apply for a waiver based on that showing of hardship. What becomes a problem is if someone leaves unlawfully, re-enters or enters unlawfully, accumulates unlawful presence, leaves the United States, and then again re-enters. And then you can trigger what's called a permanent bar.
Okay. We just have a limited amount of time. I just want to ask you also, should people pay their taxes even if they're not documented?
Yes, Ken, it's very important. There are certain programs where if someone is placed into deportation proceedings while they're here in the United States, based on having been here out of status, but they've been here more than 10 years, they have a family member, a parent, a spouse, or a child who's a U.S. citizen or a lawful permanent resident, and if they could show that that family member would suffer extreme hardship if the immigrant were to be deported, they may qualify for what's known as cancellation of removal. And they would go before an immigration judge and make this showing of extreme hardship. And if they're able to do that, and if they can show that they have good moral character, they can be permitted not only to remain in the United States, but to gain status as a lawful permanent resident.
So paying taxes will help with that, even if they're off the books.
Exactly, Ken. Even if someone's in this country unlawfully, if they are working, they're required to pay taxes. And it's very common for immigrants, even if they're out of status, to gain or apply for a tax ID number so they can pay their taxes.
Okay.
Simply being here out of status does not relieve a person of their duty.
But it also helps create that idea of good character.
Yes,
and lastly, George, just in a moment, what can permanent residents do to try to become a citizen?
Lawful permanent resident can apply to become a U.S. citizen. The process is called naturalization. If you're married to a U.S. citizen, you can apply after you've been a permanent resident for 3 years. If you're not married to a U.S. citizen, then you can apply after 5 years. You have to make a showing that you're a person of good moral character. Generally, that means no arrests during that period, that you've paid your taxes, and you satisfy the residency requirements, that you haven't been out of the country for more than half the time, and that you can pass the civics test and the English ability.
And it's good for a person not to delay. If they're eligible to become a citizen, they should apply because there's always a chance that it'll get harder.
It could always become harder. Most people never intend to fall afoul of the law, but many times it happens. If you're a citizen, if you're a lawful permanent resident, you should become a citizen and set your roots down and not have to worry about
And that will give you greater
losing
protection
them.
if you do have some legal criminal problem down the road.
Yes, Ken, because even though we say a lawful permanent resident, it's only permanent if you don't commit an offense that subjects you to deportation.
Okay. I'd like to thank George Terezakis, a very experienced immigration attorney based in Mineola, but he handles matters all over the New York area. If you missed any part of the program, go to the podcast at nccradio.org, and please join us next time at this same time for another program on Law You Should Know on 90.3 WHPC, the voice of Nassau Community College.